I want to now progress to one and only one more main head of interpretation, which is, I think, important enough for me to cover as part of the webinar, which is the principles in respect of retrospective operation of statutes. Now, again, I don't want to do it with too much reference to case law. I want to do it more by explaining it to you. Now, retrospective operation of statutes is when you say a statute operates retrospectively, what you are really saying is that a law which is enacted today or at a particular point of time has the effect of applying and governing or unsettling rights and duties and obligations which have already vested or accrued at a past point in time. That's a retrospective operation of statutes. That is, you are not merely looking to regulate the present and the future, but you are also looking to regulate the past. That means matters which have closed, transactions which have concluded, rights which have accrued and vested are all going to be reopened and unsettled by a retrospective operation of statutes. Now, what therefore is, from the point of view of interpretation of statutes, what therefore is this rule that we so commonly refer or describe as retrospective operation of statutes? The principle of interpretation of statutes is that there is a presumption, and it's only a presumption, that a statute will operate prospectively. That means we will first read a statute in a way to see whether it would operate prospectively. If there is any ambiguity or if there is any doubt, then the statute must be read so as to apply to a future point of time or must apply prospectively. But that does not mean that the presumption that a statute will first apply prospectively cannot be negated or rebutted by clear language in the statute. In other words, a legislature with the plenary powers that it has to enact law can also enact statutes which will operate retrospectively. So the rule is not that a statute cannot operate retrospectively. There is no absolute rule of that nature. The rule is only that a statute would be presumed to operate prospectively unless there are clear words in a statute that apply it to a past point of time or that apply it retrospectively. That's the first limb of the rule. And the second component of this rule or this aid to interpretation is that the presumption that a statute will apply prospectively does not apply to statutes which govern procedure. That means when it comes to a matter of procedure, because I think that the thinking or the rationale is that no person can have a vested right in procedure. Procedure is dynamic. That when it comes to a provision which is procedural in nature, you will not even apply the presumption that it applies prospectively. It may well apply retrospectively, and the courts are much more lenient in construing procedural provisions to apply retrospectively. When it comes to substantive provisions, they can apply retrospectively, subject to the presumption, and only if there are clear words in the statute to that effect. Now, very quickly to give you one or two examples by way of case law on retrospective operation of statute. Sorry, before I come to the case law, I also do want to make this point that if legislation does contain clear words to apply it retrospectively, then it is oftentimes challenged and amenable to a constitutional challenge under Article 14 of the Constitution of India. And when such retrospective legislation is challenged, what the courts have essentially said is that there must be a very good and valid reason, for example, a public purpose or an exigent circumstance, take the COVID pandemic, which justifies, overwhelmingly justifies the operation of a statute retrospectively to unsettled, accrued, or vested rights. That's really how the courts would approach a constitutional challenge to a legislation that does operate retrospectively. There must be some compelling reason it may be founded in public purpose, or one other reason why acts are often made retrospective, even in respect of their substantive content, is when, for example, there is a clear lacuna in an earlier legislation, which people may have taken advantage of. And the legislature feels that it is necessary to go back in time and to cure that defect. That is perhaps another reason why the legislature can enact law to apply retrospectively and which would withstand a constitutional challenge under Article 14. So that's really the principle of retrospective operation of statutes. There are two judgments which are there in part 2 of the note, which is in the case of Shekhar Gole and BCCI Kochi. Now, in Shekhar Gole, you can read it in your own time. I don't want to get into reading of judgments because I believe I've already spent a little over an hour. In Shekhar Gole, what the Bombay High Court was considering was a constitutional challenge to a provision of the Maharashtra Cooperative Societies Act, which undoubtedly operated retrospectively. When I say undoubtedly, means the court concluded that yes, the plain language is such that it does operate retrospectively. But in that judgment, the court went on to analyze in great detail what are the tests or the circumstances in which a court can enact retrospective legislation. I've summarized them for you, so therefore I'm not going to read the judgment, but I do believe that it is worth looking at the judgment if you ever do need it, either as part of your academic pursuits or as part of your pursuit in law. I think that that judgment is a very helpful judgment in analyzing this entire gamut of law and in relation to retrospective operation of statute. And the last judgment on retrospective operation of statutes, which I want to touch upon, is a judgment of the Supreme Court in BCCI versus Kochi International. Now, this is one of the IPL cases. And this judgment really involved a very, very important series of legislations and amendments in the field of arbitration law. Many of you would know that for the longest time, one of the deficiencies in arbitration law was that an award of the arbitrator was automatically stayed under the provisions of Section 34 and 36 of the Arbitration Act. And you didn't even have to apply for a stay. And that was a huge setback in the whole efficacy of arbitration, because you might have a very efficient arbitration process, but it comes to naught the minute your 34 is filed and it's admitted and there is an automatic stay. So in 2015, by an amendment act, the automatic stay provision was done away with. And that was challenged. Ultimately, it went before the Supreme Court, and it was not so much a challenge, it was more a question of interpretation of the amending provision. And you can read, of course, that judgment, which is part of the note. It is analyzed in the table of cases. But the point that I want to make over here is relevant to this question of retrospective interpretation of statutes, is that Justice Nariman came to the conclusion that the lifting of the automatic stay does operate retrospectively. That Section 36 amendment does operate retrospectively because it applies even to pending cases that had been filed challenging awards under Section 34. But what he said was that the process of execution is procedural in nature. And because the process of execution is procedural in nature, that the process of execution is procedural, it's found in the CPC in Order 21, no person can have a vested right, even in respect of the process of execution that may have already commenced, or the process by which he gets an automatic stay on execution. And since it is only procedural in nature, Justice Nariman held in the BCCI judgment that there is nothing arbitrary if that procedural amendment applies retrospectively to Section 34 petitions that had already been filed, and hence he came to the conclusion that it is an appropriate interpretation because the presumption that you will not apply a provision retrospectively does not apply to procedural provisions. And hence he said that it applies, and the effect of that was that there was no automatic stay, even in cases where awards had been challenged under Section 34. You could only obtain a stay by either making a deposit or by convincing a court that the award is so arbitrary and egregious that it requires an automatic stay. But you could not take it as a matter of course, which is really the lacuna in the Act as it stood before. So these are two of the judgments on retrospective. Now, the last judgment that I want to make a reference to, which I think is really helpful because it puts all of this into context and summarizes all of this. And if you do want to read one judgment, which is as good a summary as you can get on the evolution of interpretation of statute by our courts, I would say it's the judgment, again, and no prizes for guessing who my favorite Supreme Court judge is, Justice Nariman, in the case of ERA versus NCT, where what Justice Nariman did in an interesting matter involving POCSO, which is the protection of children against sexual offenses. You'll recall I made a reference to it in part 1 of my webinar, is to develop what he called creative interpretation. Now, in the POCSO judgment, what the court does is that really the court was considering a question. Before I come to what the court does, let me tell you what was the issue before the court. The issue before the court was that when we look at the definition of a child under a social and penal statute like POCSO, are we looking at the calendar age of a child or are we looking at the mental age of a child? Now, that was a case where the sad case of rape was being tried before the regular courts, and there was no progress being made in the trial. And therefore, the guardian, who was the mother of the victim, made an application saying that there is medical certificates to the effect that although the rape victim in question was above 18 years of age in the calendar sense, her mental age was less than 18. And therefore, she qualifies within the definition of child under the POCSO, that is the act in question. And she therefore wanted an interpretation of the word child in a purposive way to protect not just somebody who is actually under 18 years of age, but somebody who in their mental state is under 18 years of age. Ultimately, Justice Nariman did not uphold that interpretation. But in not upholding that interpretation, or before he rejected that interpretation, what he did was to, in great detail, analyze the history of statutory interpretation by courts in India. And in analyzing the statutory interpretation of the courts in India, including by citing various judgments that I have referred to, which analysis begins in the very opening of his concurring decision. Ultimately, what Justice Nariman holds is that you have to take a holistic approach to interpretation. You can't take a compartmentalized approach. And he calls this holistic approach something known as a creative interpretation applied by the court. And for example, he uses that expression in paragraph 122, 123, and he then says in paragraph 124 that the modern trend is to examine the text as well as context and object or purpose as well as the literal meaning. And this is really what is the current position of the law, or the accepted position, that you really are not choosing between different aids of interpretation. You are applying all of these together in a way where it really becomes a question of degree. That means in a given situation, in a given factual context, as a matter of degree, you will lean towards the purposive approach or the contextual approach. In other situations, you will lean towards the literal approach or the plain language approach. But as he says, this is a matter of degree and it's a matter of striking balance. It's not a matter of choosing one over the other. And therefore, this is the judgment which I wanted to conclude the webinar with, because it's a comprehensive analysis of the law of interpretation. I only wanted to just end with a disclaimer that there are many subsidiary aspects to the subject of interpretation of statutes which I have not dealt with for want of time. But I'll only indicate them because you must know what I have not covered, and your separate and your independent reading may cover it. I have not dealt with some of the subsidiary rules of interpretation which explain how you must interpret a proviso or a non-obstant clause or clauses which oust the jurisdiction of a court. There are again separate judgments which describe, and some of them are in my note which you can look at, what are external aids to interpretation that can be looked at and internal aids to interpretation. Then there are some judgments which tell you that some types of legislation must be presumed to be strictly interpreted, or rather the rule of strict interpretation must apply, and to others liberal interpretation. Although this presumption or presumptive approach to interpreting legislation is now, according to the Supreme Court, not the correct approach, and that you have to apply the same principles of interpretation, especially because it's sometimes hard to compartmentalize legislation. If you look at POCSO, POCSO is as much a social legislation as it is a penal statute. So therefore, you can't really start with a presumption. You have to apply the same unified approach to interpretation as you would to any other legislation. Then taxing statutes, there are judgments which say that tax and equity make strange bedfellows, and that therefore in a taxing statute you will simply take the language for what it says and not try and dig beneath that to what the underlying rationale of a taxing statute is. And then there are completely different topic within interpretation on the interpretation of repeal and savings clauses and section 6 of the General Clauses Act. Time does not allow me to get into all of these various topics, but I thought I would put it out there for all of you to pursue as part of your independent study. And one parting remark, and this is a general remark from a practitioner's perspective, is that in the cases that I have done, and in many of which I've had to ultimately make submissions on the interpretation of a statute, very often the dilemma in my mind is in trying to understand whether the judge is going to use an aid of interpretation to reach a conclusion in a matter, or whether a judge has already reached a conclusion in the matter and he is going to use an aid of interpretation to justify that conclusion. And I think that's really my uncertainty when I argue a matter. But what generally works for me, because ultimately it depends from judge to judge. There are some judges that have the reputation of being very textual and literal. There are others who have the reputation of being more holistic and broad-minded and equity-oriented. And therefore, perhaps that will have a bearing on how you approach a matter as a counsel, as an arguing counsel, as a practitioner. But it's nevertheless very important to study this subject and to study it exhaustively, because there is hardly an important matter in any field of law which goes or reaches a conclusion without actually involving a very necessary process of interpreting statutes or interpreting the legislation at hand. And this is the bedrock of all litigation. So I cannot overemphasize the importance of this subject. And I'm grateful to have had the opportunity of revisiting this subject again as a result of these webinars. So I will conclude with that.
Backtracking to the term of legislative intent that you covered in your last webinar, last paragraph, which is a quote on page 6 of your note. Can you clarify the words supremacy of statute over common law in another example?
Well, I think supremacy of statute over common law. Let me give you an example of supremacy of statute over common law and try and find a concrete example. In the airline industry, suppose you did not have, of course, the airline industry doesn't exist today, but when it existed and when it was robust, I recall that in the 70s and in the 80s, there were many conventions all over the world which limited the liability of airlines for things like lost baggage, lost luggage, etc. Those conventions then became part of codified law in India. What codified law then did was to limit the liability of airlines. So that codification of the law must be understood in the context of what was the common law before that. The common law before that, perhaps being the law of torts or the law of contracts, did not limit such liability. But codification of that law which came in, expressly conscious of the common law, chose to limit liability. And that is, for example, that is an example or an apt example of supremacy of Parliament. Parliament is now saying, enacts law, it has the power to enact law, that whatever may have been your common law remedy in contract or in tort for negligence against an airline, we are exercising our supremacy to codify that law and to say that for every bag lost, you will not get compensation of more than, let's say, 5,000 rupees. And they fix a figure. That is an example of supremacy of Parliament. And I think that what that last part of the introductory note is really trying to communicate is no more than this, that through the process of interpretation of statutes, a court should not overreach the supremacy of Parliament and find a way of getting out of the parliamentary enactment to once again make liability open-ended, because that would mean, to use the language of the Supreme Court, overreaching or overstepping the boundaries of the Lakshman Rekha and undoing the supremacy of Parliament through a process of statutory interpretation. So I hope that by this example, I'm trying to highlight common law versus codified law and how the courts are then expected to respect codified law, which is really respecting the boundaries and accepting what Parliament has laid down to be the law.